based in Milton, Brisbane in Australia, and we assist people with regards to migrating to Australia. We also assist sponsoring companies here in Australia to bring people from overseas. Under the category of spouse, there are a variety of visas. They include the spouse visa, they include the de facto spouse visa, they include the prospective spouse visa, and they include the interdependent spouse visa. Very briefly, the spouse visa is when an Australian person, and that can include an Australian permanent resident, an Australian citizen, or a New Zealand eligible permanent resident, sponsors their partner, a partner that is married to them. Okay, so there is an actual marriage certificate in that scenario. When you are a prospective spouse, it means that you are engaged with somebody overseas and you have the intention to get married. If you are applying for a de facto visa, it means that you have been in a spousal relationship with somebody for a period of 12 months immediately before applying, and there has been cohabitation in that relationship. The fourth option is your interdependent visa, and that's a gay relationship. And that includes cohabitants and a relationship for a 12-month period. Under each of these options, the underlying and fundamental criteria of the Department of Immigration is that there is a genuine and continuing relationship to the exclusion of all others. One may obviously ask, how do you actually evidence a genuine and continuing relationship? The Department of Immigration look at 4 factors of your relationship, and based on the totality of that evidence, they determine if there is a genuine relationship. The first aspect the Department of Immigration looks at are the financial aspects of the relationship. So do you and your partner combine your finances as any normal couple would? Now this can include, but it is not limited to, the joining of bank accounts, the joining of paying fees and dues equally. Now these can include electricity bills, rates bills, rental bills. It can include a whole variety of things. There is no black and white checklist with regards to what financial aspects you need to illustrate. Once again, it's the totality of the evidence you have with regards to finances which would actually illustrate a genuine and continuing relationship. The second aspect the Department of Immigration looks at are the household aspects. So do you and your partner actually reside together? Obviously, if you're applying for a de facto or an interdependent partner, well, you need to show or illustrate some cohabitants. So you illustrate that you guys are actually living together, whether it's overseas or here in Australia. Some people who are applying for spouse visas and prospective spouse visas, however, may not have the opportunity to live together. They may have been together for short periods of time, but they don't have substantial evidence of joint residency. That is okay, but you should still illustrate the periods of time that you have physically been with your partner, whether it's in Australia or whether it's overseas. The third aspect the Department of Immigration looks at is your social aspects. This is how you and your partner portray your relationship to the world at large. So does his family know about the partner? Does her family know about the partner? Do your friends know about the partner? Do your workmates and colleagues know about your partner? I would strongly recommend that statutory declarations in support of your application be provided by family, friends and acquaintances who know of your relationship and have done social activities with you. These social activities could include, but of course are not limited to, having barbecues, going to family christenings, going to family barbecues, going to the beach with a group of friends. Any evidence which illustrates you are doing these social activities is good for your application. The fourth aspect which the Department of Immigration looks at, and the final one, is the level of commitment in the relationship. Now this can include a whole range of factors. I usually advise my clients that if you have made the decision to get married, then that is a commitment within itself because it is a quite important and large step in somebody's life. If you have a child together, that is a commitment in itself. If one of you move to another country to obviously be with the other partner, that I believe is a commitment in itself. Each person's circumstances and relationship will illustrate a commitment in its own right. There's no, once again, textbook rule as to what is a level of commitment in a relationship. So depending on your circumstances, you ascertain what level of commitment there are and bring that to the attention of the case officer who is actually addressing your application. In summary, it doesn't matter what spouse visa you actually apply for. The underlying and fundamental requirement is that you are in a genuine and continuing relationship to the exclusion of all others. A few finer details. Of course, if you are applying for a spouse visa, remember you actually have to be married. If you are applying for a prospective spouse visa, you actually have to be engaged with your partner. Now, these applications are actually done offshore, so whilst your partner is overseas. Included in your application, you need to provide evidence that you have physically met your partner and that you have a notice of intention to marry. And that notice of intention to marry needs to be within a 9-month period of when your partner is granted their prospective spouse visa. The way the prospective spouse visa works is essentially in 2 stages. You apply for your prospective spouse. Once that is granted, your partner comes over to Australia from overseas and has a valid 9-month visa. Within that 9-month period, then you and your partner are to get married. If you decide not to get married, well, then your partner will need to actually leave Australia or determine if there are any other options or rights to apply for another visa onshore. Remember, if you're applying for a de facto visa, you need to illustrate 12 months of joint cohabitance or of a genuine relationship. And once again, the same rule applies if you're applying for an interdependent partner visa. Whatever visa under the spouse category you may apply for and be granted, it is only a temporary visa. So it is only a 2-year visa. After those 2 years, you will receive a letter from the Department of Immigration asking you to provide further information and evidence that you remain in a spousal relationship with your Australian partner. Once you can illustrate that, then the Department of Immigration will issue you a permanent residency visa. This information provided to you today is very brief and is only for summary purposes. It is not recommended that based on this information you proceed with lodging a spouse visa. Should you require any further information with regards to spouse visas, please visit our website on www.noborders-group.com. Equally available is the Department of Immigration's website at www.immi.gov.au, or you may contact our office on 0061 if you're calling from overseas, 7 for Queensland, and our telephone number domestically is 3876 4000. Spouse visas are very important, and although today's session may have been very brief and it seems quite easy, I do recommend strongly that you seek further assistance and advice before lodging your spouse application. Your life as an Australian sponsor and your life as an overseas applicant are at stake, and you want to make sure that you apply for a valid and provide a complete application for a case officer to adjudicate favourably.